News Channel 7. This is the news at 6.
And Title IX and equal protection should allow boys to participate in boys sports and girls to participate in girls sports, and should allow girls to have the safety and security of knowing that they're going to be safe in their spaces.
Idaho's Attorney General Raul Labrador was outside the U.S. Supreme Court in Washington, D.C. today following oral arguments in Little versus Hecox. The ruling could determine whether states can legally bar transgender women and girls from girls and women's sports. Aspen Shumpert tracked the arguments today, and Aspen, a decision in this case could affect dozens of other states.
Right, Morgan. While Idaho was the first to pass a law like this one, 26 other states have gone on to pass similar ones. Today, both sides of this argument made their case.
We will hear argument first this morning in case 2438, Little versus Hecox.
2 hours of oral arguments at the U.S. Supreme Court debating whether Idaho's first-in-the-nation law banning transgender girls from girls' sports teams is constitutional.
Idaho's law classifies on the basis of sex because sex is what matters in sports.
A lawyer from Idaho's Attorney General's office, Alan Hurst, defends the state, saying if women don't have their own competitions, they won't be able to compete.
Sports are assigned by sex because sex is what matters in sports. It is the fairest and the safest and the most administrable way to assign sports teams. It's been widely accepted for many decades because it's necessary for fair competition, because where sports are concerned, men and women are obviously not the same.
He pointed to unfair advantages,
like size, muscle mass, bone mass, and heart and lung capacity. Tragically, but not surprisingly, male athletes have even injured female athletes in many sports.
But on the other side of this, Kathleen Hartnett, representing Lindsay Hecox, a now former Boise State student who wanted to try out for the women's track team, argues Idaho's law goes too far
by categorically excluding all students with the biological sex of male from women's teams. Sex classifications like that are closely scrutinized under the Equal Protection Clause to ensure they rest on evidence, not supposition.
Hartnett says not all transgender athletes have physical advantages. She pushes back on Idaho's blanket ban.
On this record, Lindsay Hecox has mitigated that advantage because she has suppressed her testosterone for over a year and taken estrogen. HB 500 thus fails heightened scrutiny as applied to Lindsay and transgender women like her who have no sex-based biological advantage as compared to birth-sex females.
The justices wrestled with the big picture.
One of the great successes in America over the last 50 years has been the growth of women and girls sports, and it's inspiring.
Justice Brett Kavanaugh says groups like the NCAA and the Olympic Committee have studied this issue.
These are a variety of groups who study this issue, think that allowing transgender women and girls to participate will undermine or reverse that amazing success and will create unfairness.
But Justice Ketanji Brown Jackson challenged how the law works in practice and why Idaho can't make individual exceptions.
I would think the state would just have to make exceptions where people can demonstrate that the justification that makes the state's conduct constitutional doesn't apply to them.
Directly after Idaho's case, the Supreme Court also heard arguments in a similar case from West Virginia today. Both cases challenged state laws banning transgender girls and women from girls and women's sports teams. Morgan, no decision was made today, but the Idaho Attorney General's office tells me an update on this case is expected in June or July of this year.
Okay, thanks for recapping that, Aspen.